Which negligence defense applies to your personal injury claim? Imagine you're walking down the street and get hurt in an accident. Now, you might wonder what defenses the other side could use to challenge your claim. Let's explore the common defenses and how they might relate to your case. First, one of the most well-known defenses is contributory negligence. This means the defendant claims you were partly responsible for your injury. In some states, if you are even a little at fault, you might not recover any damages at all. For example, if you were jaywalking and got hit, the defendant could argue you contributed to the accident. To counter this, you need to show that the defendant's negligence was the main cause of your injury. Next is comparative negligence. This defense is similar but more flexible. It allows you to recover damages, but the amount is reduced based on your percentage of fault. So, if you are found 20% responsible, you get 80% of the damages. Some states have a rule where if you are more than 50% responsible, you cannot recover anything. This means your case depends heavily on proving the defendant's fault was greater than yours. Another common defense is assumption of risk. This applies if you knowingly took a risk and accepted the possibility of injury. For example, if you signed a waiver before participating in a dangerous sport, the defendant might say you assumed the risk. There are two types: express assumption of risk, which involves a written agreement, and implied assumption of risk, where your actions show you understood the danger. To fight this, you need to prove you did not fully understand or accept the risk involved. Lack of causation is another defense. The defendant argues their actions did not directly cause your injury. They might say your injury was due to another factor or pre-existing condition. To win against this, you must show a clear link between their negligence and your harm. Pre-existing conditions can also be used as a defense. The defendant claims your injuries were worsened by a condition you already had, not solely by the accident. You need to provide evidence that the accident caused new injuries or made existing ones worse. Finally, open and obvious hazard can be a defense in slip and fall cases. If the defendant claims the hazard was clear and you should have seen it, they might avoid liability. To counter this, you need to show that the hazard was not obvious or that it was hidden in some way. Knowing which defense might apply depends on your specific situation. If you were texting while driving, the other side might argue contributory negligence. If you signed a waiver before a risky activity, assumption of risk could come into play. Understanding these defenses helps you prepare your case and anticipate what the other side might argue.